It's interesting because the word facetious occurs in a recent important Supreme Court decision on gay rights, where the gay cause is characterized as facetious. And words like that, I think, don't make their way into normal children's vocabularies unless they're hanging out with lawyers.
That's the Hardwick decision?
Yeah. Justice Byron White chose to trivialize the position of people who are challenging the sodomy law by calling the privacy argument that Michael Hardwick, who was arrested in his bedroom, and others have made, a facetious argument, which I think is, it gives away a lot. I think it says a lot about the status of lesbians and gay men in law.
I know you've talked about Hardwick. I've always liked that you cut to the quick and you say, this is one of the cruelest decisions of this century. Why don't you just sum up quickly what Hardwick was about for viewers that may not know?
Briefly, Georgia has a so-called sodomy law, and the word sodomy is meant to conjure up the image of anal intercourse between two men without benefit of a condom. But in fact, this law prohibits all oral genital and all anal genital sexual contact, and that's a lot of sex. I mean, if we're to believe the studies, that's a set of sexual experiences that most people have.
I mean, who among us has
right. I like to
violated?
ask my voluntary audiences to raise their hand if they've violated the Georgia sodomy law, and usually I see lots of hands, most everybody in the room. Georgia had this law, and what happened was that Michael Hardwick was arrested in his bedroom for an act of oral sex, voluntary, adult, private, consenting, all of that. No commerce, no children, no coercion. None of the 3 C's that Professor Tribe, in arguing for Michael Hardwick, identified as conditions or restrictions on sexual freedom. And the court nonetheless upheld the right of the state of Georgia to massively restrict people's adult sexual autonomy. And I think I'm pretty sure that people still don't realize how traumatic that decision is to the body of law, to the average individual's expectation of privacy. I mean, I think people don't get it. It's a massive body blow.
Yes, and certainly not a massive blow to gays in particular. It was such an emotional decision for gays.
You know, that's very true, and I think people fail to realize how provocative that decision is, because what it does is it elevates to a level of rectitude and correctness the proposition that gay people are criminals in 25 or more of the 50 states, and 23 or 4 now have, enforced or enforceable sodomy laws of the Georgia type, meaning covering a lot of different kinds of sex. And theoretically, every state in the union could reenact its law in light of Bowers versus Hardwick. Some of the AIDS pandemic hysteria sees its way into people wanting to recriminalize, and there's so much at stake in that case. It's hard to take it apart without just saying there's an awful lot there. I think that there are implications for Roe versus Wade and for the survival of the right of abortion choice, at least if the Supreme Court is going to be careful and consistent about the right to privacy. Everybody's sexual privacy was jeopardized and cut into by Bowers versus Hardwick.
Right. Lawrence Tribe is Professor Lawrence Tribe, who argued the case, Harvard Law School, and I always like that you make a lot of how he framed the issue.
Well, he framed the issue with great emphasis on the privacy of the bedroom. And we, some of us who wrote amicus brief, friend of the court brief, put a greater emphasis on the privacy of the individual to make an autonomous adult choice. I think bedrooms are only private where people are behaving in them in a way that's respectful of one another, that's nonviolent, that doesn't involve some degree of coercion or harm. I think the emphasis on autonomy of the adult, on making moral judgments, should have been the correct emphasis. Even so, I don't mean to criticize Professor Tribe in my comments, because I think he would have lost either way. I think the court was sufficiently homophobic. The court majority was sufficiently dedicated to cutting off the rights of gay people. They would have done it whatever his argument.
Right.
The dissenters, by contrast, were brilliantly committed to sexual autonomy. Harry Blackmun's dissent will someday be good law. It will someday be the law of the majority. Meanwhile, we live in the present, and in the present the law is a very devastating institution for sexual minorities, gay, lesbian, bisexual people.
Let's get back to Napa.
Napa. We got to go back to Napa?
Yeah, let's go
All right.
back to Napa. And your mother worked outside the home. She was a teacher.
Right.
And you are, a Stanford professor. You teach, and it's all about teaching. But in particular, there seems to be a draw that I haven't seen before to teaching formally in an institution of late.
I feel like it's all teaching. I feel like our job, the collective job of people who care about seeing the business, seeing the challenge of the 60s be made the fulfilled promise of the 80s and 90s, that it's all about education. And it's interesting that you mentioned my mother, because I think a significant part of my motivation to doing civil rights advocacy came from watching her experience. She is a disabled person. She lived through the polio epidemic. She was left paraplegic and a wheelchair rider. She was left with a great deal of harm. And I think as a little kid, watching her brave the elements of the universe and seeing the injustices doled out her way is part, it's not all, but it's part of what made me and makes me committed to this cause. It also makes it very easy for me to see that the rights of disabled people, the rights of people of color, of women, of gay and lesbian people, of every identifiable oppressed group are connected. You do not win justice for one without affecting the plight of all. And for that matter, you don't inflict injustice on one without harming everybody.
It really explains a lot to me, that combination of your father, and it must have been very painful to embrace his career and some of the skills and so on, yet you had a very adversarial relationship, and then a disabled mom that really encompasses all those, the kind of downtrodden or disenfranchised. It explains the drive in you to really want to represent people.
Yeah, it's part of it. It's definitely part of it. In a way, now at the ripe old age of 40, amidst this environment of recovery and the recognition of the ways in which my life needs to change, I've had to look again at my motivations and say, well, but am I truly committed to this for my own rights, for my own liberty, as a person who is herself affected by the oppressions of the system? And the answer is yes, but the answer is not as quick and coming as jumping in behalf of others, moving to protect the rights of someone other than myself.
In the 1970s, you appeared in the United States Supreme Court on behalf of pregnant women.
Right. Pregnant school teachers. Right.
Pregnant school teachers.
That's all. A refinement.
And then in the 80s came the Gay Olympics case. What was it like? Can you compare and contrast those experiences of arguing in the United States Supreme Court, first as an attorney and then as an openly lesbian attorney?
Well, I wore a dress both times, for those who wonder about that, and that symbolism is interesting to me. I think it signified a certain willingness to be vulnerable in that court. But they all wear dresses too, after all. And first time around, I was very openly and committed feminist in my vocabulary and my manner and my orientation, if you will. And 10 years later, I was as openly a lesbian in the Supreme Court as I could imagine being. And I came there on a lavender wave. There were easily 100 people in the courtroom wearing pink triangles and arguing with the security guards about whether those were jewelry or political symbols. And the room was simply filled with a gay and lesbian presence. And the court felt it. And there were court personnel who were out for the day, or at least visible for the day, and who were, I think, proud to stand beside Tom Waddell and the others who had been the symbolic and real carriers of the cause to the court. It was exciting. It was fun. It really was fun. And I think we changed the court in some kind of environmental, psychological way. I think they won't listen to gay and lesbian cases the same way in the future. The homophobes will go on being homophobic until and unless they can begin to understand that that is another form of injustice. But in the meanwhile, some of the others who were kind of in the middle, I think, began to feel the humanness of the cause and the momentum of it, and that was very exciting. Well beyond the specific issues that I was there for. I think we made a kind of a dent in their armor.
We only have a few minutes left, but we have pregnant school teachers in the 70s and the Gay Olympics in the 80s. What do you think the 90s will bring?
Significant intrusions upon the civil rights of people based on the hypothesis that the government is going to control substance abuse at all costs, We see that already. Drug testing everywhere. Going to have to pee in a jar to go to the movies pretty soon. And what I'm getting at is that I think the Bill of Rights is as much in jeopardy looking down the road, even when we overcome the significant discrimination against traditionally oppressed, the groups that have already been identified as being the victims of societies and the legal system's worst discrimination. We still have a capacity in the system to oppress. And it's still there. It's still intact.
Well, Mary, we're out of time, and as we say really often with interesting guests like you, that there's just never enough time, but thank you so much for coming.
There's enough time. It's just that after the program, right? Onward.
Yeah.
Okay.
That's our show for tonight. I'm Elizabeth Birch, and for Paul Wysocki and all the crew here at Outlook, thank you for tuning in, and we'll see you again next time. Bye-bye.